Thank you very much, Victor. I neglected to mention in my introductions that there are biographies of all the speakers in the materials, so we're basically dispensing with that and just identifying the folks before they come up. Our next speaker, Bob Peck, is with the Center for Constitutional Litigation and is a premier appellate litigator, argues numerous cases in appellate courts around the country as well as the U.S. Supreme Court.
Thank you, Henry, and thank you to the Searle Center for having me and having me join my friend Victor on the podium once again. It's also a pleasure to be at a podium where there's not a wooden crank that I have to half cock just to show the justices I know what I'm doing. On Wednesday, as Victor said, I argued Philip Morris versus Williams. This was our third trip to the U.S. Supreme Court. The topic is emerging civil justice issues. And I've got to say that the history of constitutional law has been one of increasing the franchise, increasing participatory democracy. And the history of civil justice in the constitutional context has been increased access to the courts. Now, neither of these have taken a linear trend. All of them have had their ups and downs. But we have put ourselves on a course that we basically have stayed on ever since Marbury versus Madison declared that it was the first duty of government to assure full and fair redress for all who have been injured. And so that is part of the objective of our civil justice system. And while we may dispute whether certain things advance it or don't, the fact is that's our goal. That's our goal. And the goal has been largely met by looking at very innovative suits. Even de Tocqueville, almost 200 years ago, observed that almost every political question in America ends up being resolved as a lawsuit. And that is because we have an orientation. Our Declaration of Independence essentially was a legal set of grievances, and that is part of our heritage. Now, when we look at what the court has done in recent years, we look at a court that the New York Times, for example, characterized as the Supreme Court Incorporated because of a newfound business orientation. I think it's much too premature to assume that the court is basically going to look at business cases and also always favor business. I think that for a while the court ignored business, ignored those kinds of cases, and so there was a pent-up group of cases waiting for the court to take. And when John Roberts and Justice Alito joined the court, these were cases that they were familiar with, issues that they were familiar with, and so they helped bring those to the court. And we've seen most of them now come to the court. I think the court's going to take on a different character as the issues become new and not familiar, and as also other issues begin to intrude on the court, and that's been also part of the history of the court. But one point that I think is very important, and Victor brought it up, is what the court has done in punitive damages, because it tells you a little bit about what the court does when it begins to freelance, as it did in the punitive damages area. Now, punitive damages has amounted to the new obscenity. If you'll recall, in the late 50s, the Supreme Court suddenly said obscenity was not covered by the First Amendment. And then Potter Stewart, much to his later regret, said, it may be undefinable, but I know it when I see it. And as a result, the court would actually take a great many of these obscenity cases. They would actually feel the obligation to watch the film in the basement theater of the Supreme Court. And even Justice Harlan, who was blind at that time, felt duty-bound to sit through these showings. And Thurgood Marshall assigned to him himself the job of describing what was going on screen to Justice Harlan. The court was stuck with this until 1969, in a case called Miller versus California, where they suddenly declared community standards will define this, and they stopped getting into the obscenity business. Now look at the parallels here in punitive damages. They take some punitive damages cases, they don't disturb those verdicts, but Justice O'Connor in dissent says that we're facing skyrocketing punitive damages. This is a problem that we need to address. And slowly and haltingly, the court gets to the point where they suddenly say in BMW versus Gore in 1996 that there are going to be 3 guidelines and that it's a due process issue. And we're going to see that punitive damages are reduced when they fail to meet these guidelines. They then take a revolutionary step in 2001 in the case of Cooper Industries versus Leatherman Tool Group, where they reverse 150 years of precedent to say that, at least for Seventh Amendment purposes, punitive damages are no longer a decision to be made by the jury and thus not subject to reexamination. We are going to engage in de novo review, and on top of that, we're going to say that, they've evolved. They once had a role somewhat similar to compensatory damages, non-economic damages, that sort of thing. That's still the jury's province. But here, punitive damages are simply an expression of the jury's moral outrage. And so therefore, we're now writing on a blank slate. We can re-examine the record. We can come to our own conclusions. Appellate courts can set punitive damages. And so that progression continues with State Farm versus Campbell, in which they suggest that a single-digit ratio is more likely to comport with constitutional standards than 500 to 1, but 500 to 1 in some instances would. And even in some instances where there's a substantial award, maybe 1 to 1 is close to the constitutional line. We get to Williams, and they punt in the first of these cases that involve personal injury and a long-standing corporate campaign. And so instead, they decide this jury instruction issue. And the jury instruction issue, as Victor described to you, is that, yes, you can have evidence of harm to non-parties. You can argue about the impact on non-parties. And that goes to reprehensibility, which is the most important indicia of the size of a punitive damage award. But you may not punish directly for harm to non-parties. If you were to look at an illustrated dictionary, you would see the scarecrow from The Wizard of Oz going like this. Because, as Justice Stevens said in his dissent, the nuance eludes me. So, rather than decide the excessiveness issue, they decide this jury instruction issue. And they send it back to Oregon, which finds the jury instruction still faulty because it's materially misstated Oregon law. And that was the issue, whether the Oregon Supreme Court was engaged in an adequate and independent state law ground, or were they acting in defiance of the Supreme Court when we discussed this past Wednesday. But then Exxon Valdez comes, and it's a maritime case. And in federal court has common law authority over maritime cases. And so they have another chance to re-examine this without the strictures of the Constitution and without worrying about federalism and all those issues. So they do so. And they look at the empirical evidence and they say, my God, we were convinced that punitive damages were this widespread, horrible thing, that these outrageous awards were constant. Instead, now that we've seen the empirical evidence, it's not much of a problem. Juries are acting responsibly. The awards are less than 1 to 1. And so therefore, we don't have to worry about fairness. Fairness seems to be covered by the standard features of our civil justice system. But we're a little concerned about consistency because there are these outlier awards. Now, here's the fault of justices trying to go empirical. They looked at the empirical evidence, but they didn't look at the actual awards of these outliers. And as it turns out, all the outlier cases were low compensatory damages where they've said higher ratios are justified. And so therefore, there were no actual outliers. Nonetheless, the court says, because it seems generous on our part, if they're less than 1 to 1, to say 1 to 1 in this instance, where Exxon was the good corporate citizen. They didn't authorize drunks to drive those super tankers. They had a rule against it. They went out of their way to spend billions on cleanup. They paid fines. This was not reprehensible conduct at all, and nonetheless, a Supreme Court that's been concerned about large punitive damage awards approved a $507 million punitive damage award. So that tells you that, they're playing both sides here, but they're also saying, gee, we're not sure what's going on here. And that seems to be the case in the Williams case, as I argued it too. The court is looking for a way out of this conundrum. Every disappointed defendant in a punitive damage case seeks cert in the Supreme Court. Now, here's two things that are pretty much unknown, though. I had another case, a case in which I opposed certiorari, where the other side claimed because there was a substantial compensatory award, there should be a 1-to-1 ratio as well in punitive damages. And this was filed last November. The court held it while it was deciding the Exxon Valdez case. In this case, Continental Carbon versus Action Marine came out of the 11th Circuit. And we were worried when the court came down in June with their 1-to-1 ratio. We said, gee, that's exactly what the other side's asking for. They could GVR it, grant, vacate, and remand, send it back to the 11th Circuit, and say, see if our opinion here has any effect on you. Instead, 2 days after they rendered the Exxon Valdez decision, they denied certiorari. That tells you a little bit about how that analysis does not apply to the due process analysis that goes on. The other thing which Victor picked up on, which the court has said also, is that you should look for like cases. The problem is, as you know better than the Supreme Court, none of whom have any trial level experience, trials make a difference. What happens in the courtroom makes a difference, and the facts and the misconduct and that sort of thing is not always identical, even if it seems that way if you're merely familiar with the general outline of it. Another punitive damage case that I handled on appeal was a bifurcated trial. This big corporation, which operates stores all over the country, had falsely imprisoned this elderly couple on the assumption that when they took their morning walk around the store that they must have been dumpster diving and employees were in on this trying to give them something even though they found nothing. So they brought this wrongful imprisonment case against the corporation. They won on the liability phase and won compensatory damages. Then there's a second trial on punitive damages. And they brought in one of their corporate executive vice presidents who said, as far as I'm concerned, we did nothing wrong and we would do it again today. Now, this is after liability's already been assessed. Now, I don't know who advised him, but this was not calculated to hold down punitive damages. And if indeed punitive damages are a function of a jury's moral outrage, well, this jury was outraged. And those are the kinds of facts that you don't look at when you look at the record as a whole and you say, gee, this is just like that other false imprisonment case. No, obviously, a greater award was necessary to deter this misconduct because they still didn't get it. And so that's the other element of this punitive damage equation that I think the court still doesn't get. But they will be looking at this further. Chief Justice Roberts seemed to suggest that we might even be back a fourth time this term because although it seemed like the majority of the court realized that the Oregon courts did not do anything untoward, they thought that maybe they should now accept the second question, which they rejected, about whether or not this award was excessive. And so he said that there's the possibility we'll have you brief it and argue it yet again. So when I was told, when I was hired, the first time this went up to the Supreme Court, that this could be a case of a lifetime, I didn't realize it would be a lifetime-long case. Nonetheless, let me also say that there are other issues, obviously, in the civil justice system. Preemption, and preemption, of course, is about congressional intent. As the Supreme Court put it in the Bates case, it's about what the sorcerer says and not the sorcerer's apprentice. And therefore, whatever the court does in these cases that are currently pending, Congress can undo because it's a matter of statutory interpretation. Congress may do nothing at all, Congress may change it, but it certainly seemed in the argument of Wyeth versus Levine that the court was putting some brakes on its headlong rush towards preemption. The other thing I wanted to talk about is the fact that there is an attack these days on notice pleading. We all recognize that notice pleading was adopted quite some time ago, that we rely heavily on discovery as the engine of litigation, because it's often the defendant who has the information that either makes this litigation valid or not. And we've seen some steps in that. Twombly was, of course, an antitrust case, and it's somewhat different, but Twombly's become the most cited of recent Supreme Court cases and applied to a variety of other instances where it seems much harder to apply them. And so that's one reason why I also think that as state court judges, you have to look at your own systems as independent systems. Just as, for instance, Victor urged you to apply common law authority to punitive damages, well, the fact of the matter is, while the Seventh Amendment no longer applies to punitive damages, in most states, the right to trial by jury shall be inviolate, is the phrase, and the right to trial by jury still applies to punitive damages. And just because the Supreme Court has taken a different view at the federal level does not mean that a different view applies in states. Same thing true of your litigation systems. We have systems where discovery is de-emphasized, where you don't have a lot of those expenses. We have other systems where it's heavily emphasized. And you have to work within those systems. Those systems have a jurisprudence, a rhythm of their own that really makes a difference on how people achieve justice. And if we are going to be true to that original notion that access to justice is what we're about, then we have to look at these things carefully and not simply walk in lockstep to the latest fashion that the Supreme Court seems to be adopting. Thank you.